Start with the strongest piece of evidence, a federal judge's signed order. On January 28, 2026, Chief Judge Patrick J. Schiltz of the U.S. District Court in Minnesota issued an order in a case identified as Juan T.R. v. Noem. In that document, the judge wrote that an appendix attached to the order identified 96 court orders that ICE had violated in 74 cases. The judge warned, ICE is not a law unto itself, and ICE must follow court orders unless and until they're overturned or vacated. That is not a cable news monologue. That is a federal judge in writing describing a pattern of noncompliance and warning of escalated court actions if it continues. Separately, in Virginia, a different court fight produced another paper trail. On January 20th, 2026, a federal court order addressed whether Lindsay Halligan could continue identifying herself as the United States Attorney for the Eastern District of Virginia in court filings, after earlier opinions found her interim appointment unlawful under 28 U.S.C. paragraph 546 and the Appointments Clause. The January 20th order concluded she could not continue using that title in filings, and it warned that improper filings could expose signers to potential disciplinary action. So what's the real mid-crisis energy that the internet is trying to capture? It's this. Judges are documenting conflict with the executive branch's enforcement machinery, and the legal system, courts, prosecutors, agency lawyers, is showing signs of strain. But that's not the same thing as White House lawyers quit. That claim requires a different kind of evidence. Names, resignations, official confirmations. In the last 7 days of top-tier reporting and primary documents in our source pack, that specific claim is not verified. Now we lay it out. Confirmed versus unconfirmed. Verification block. What's confirmed versus unconfirmed confirmed. A federal judge documented alleged ICE noncompliance at scale. In the Jan 28 order, Judge Schiltz states the appendix identifies 96 court orders violated in 74 cases and warns that future noncompliance may trigger future show cause orders requiring personal appearances by senior officials. This is the closest thing in our verified record to the phrase ignores orders. But note carefully, it's framed as ICE noncompliance, not a confirmed direct presidential instruction to ignore courts. Confirmed. The underlying directive in the Minnesota case involved bond hearing relief and limits on mandatory detention arguments. 2 weeks earlier, on Jan 14th, Judge Schiltz issued an order in the same case granting relief in part, declaring the petitioner not subject to mandatory detention under a specific provision in that context, and ordering a bond hearing within 7 days, or release. Confirmed, major reporting backs up the existence and significance of those court warnings. The Washington Post reported Schiltz pulled back from forcing the acting ICE director to appear, but still issued a harsh written assessment and referenced the list of 96 orders. Confirmed, another court order, this time in Virginia, rebuked continued use of an official title and warned about discipline. The Jan 20 order states that continuing to identify Halligan as U.S. Attorney in that district ignored binding court orders and could subject signers to disciplinary action. The order also notes that DOJ had not sought a stay as of that time. Confirmed, resignations, quitting pressure exist, primarily inside DOJ and U.S. attorney offices, not confirmed as White House lawyers. The Washington Post reported prosecutors in Minneapolis were at the brink, with at least one resignation, and others threatening to quit amid DOJ handling of investigations. The Guardian reported resignations as well. House Judiciary Democrats publicly demanded DOJ answers. Unconfirmed, White House lawyers quit mid-crisis. In the last 7 days covered by this pack, we do not have Tier A reporting or primary documentation confirming a mass resignation of the White House counsel's office. What would confirm it? A White House personnel announcement named resignations verified by AP, Reuters, WAPO, WSJ, NYT, resignation letters, or official staffing changes acknowledged on the record. Until then, treat it as unverified narrative. Unconfirmed, as stated, Trump ignores orders. We do have judges alleging executive agency noncompliance with court orders. But assigning that as a confirmed direct action by the president requires explicit evidence we do not have in these documents. Reality-based phrasing, Courts documented alleged noncompliance by agencies under the administration. That's the verification. Now, how did we get here? January 6-8, 2026. The John 14 order describes the petitioner being detained around Jan 6 and filing a habeas action Jan 8. January 14, 2026. Judge Schiltz grants the petition in part, declares the petitioner not subject to mandatory detention under that provision in this posture, orders a bond hearing within 7 days, and states that if no bond hearing occurs, the petitioner must be released. January 28, 2026. The court issues the follow-up. Respondents failed to answer by the deadline. The judge describes steps taken after missed compliance. The parties file a stipulation that the petitioner has been released. The judge cancels a hearing that would have required the personal appearance of acting ICE Director Todd Lyons, but then delivers the big warning and attaches the 96 Orders Appendix. January 28 to 29, 2026, reporting context. The Washington Post reports the judge's sharp critique and the broader conflict around the surge. January 20th, 2026, parallel legal conflict in Virginia. A federal judge issues an order stating that continued identification of Lindsay Halligan as U.S. Attorney for EDVE in filings may not continue and may trigger disciplinary exposure. The order references earlier rulings about the legality of her appointment and notes no stay had been sought. January 29th, 2026. The Washington Post reports prosecutor office turmoil in Minneapolis, describing resignations and threats to quit amid DOJ handling. This matters because it's not just politics. It's the functioning of the legal system. Court orders, compliance, and what happens when a judge says the patience is running out. Now let's explain the mechanism, what these orders actually do. The mechanism, what the law and process actually are. First, what is a habeas case doing here? Habeas corpus is a procedural vehicle used to challenge unlawful detention. In immigration-related detention disputes, petitioners can ask a federal court to order specific relief, like a bond hearing or release, depending on legal findings and the posture of the case. In the John 14 order, the judge did something very specific and very checkable. He ordered respondents to provide a bond hearing under 8 U.S.C. paragraph 1226 AA within 7 days, and if they didn't, the petitioner had to be released. That's the kind of directive that creates a compliance clock. Second, what happens if the government doesn't comply? Courts can escalate. The John 28 order describes that respondents failed to answer a court-ordered deadline. Then the court issued a show cause order and scheduled a hearing requiring the personal appearance of the acting ICE director. Then, after a stipulation that the petitioner had been released, the judge canceled that hearing. But the cancellation came with a warning. The court may issue future show cause orders requiring senior officials' personal appearances. That's an institutional message. The court is signaling that non-compliance is not going to be treated as routine. Third, what does ICE violated 96 court orders actually mean in legal terms? Important nuance. The judge's order says an appendix identifies orders that ICE has violated. This is a judicial assertion within a written order. The operational and legal fight can continue through appeals, motions, disputes over interpretation, or factual disagreement. But for our purposes, the verified point is a federal judge put that claim in a signed order and warned ICE to comply. Fourth, the Virginia mechanism, why titles and appointments matter. The John 20 Virginia order is about court filings and the legitimacy of who is acting as a U.S. attorney. The order references earlier opinions finding Halligan's interim appointment unlawful under 28 U.S.C. paragraph 546 and the Appointments Clause, and states her continued use of the U.S. attorney title in pleadings cannot continue, warning of potential discipline. Even if you don't care about legal technicalities, you should care about this. Courts are drawing bright lines about who is authorized to act and what the executive branch can't simply paper over through rhetoric. Now, who are the players and what do they want? The judiciary judges. In Minnesota, Chief Judge Schiltz is documenting what he describes as widespread non-compliance, and he's warning of escalations like personal appearances. In Virginia, the court is policing compliance with its orders and professional conduct in filings. Their incentive is institutional, preserve the authority of court orders and the functioning of the system. Executive agencies, ICE, DHS, DOJ, their incentive is operational and political, enforce policy priorities, and defend the government's position in court, sometimes at high volume, under time pressure, and with legal risk. The judge's warning, ICE must follow orders unless overturned, is the collision point between those incentives. Federal prosecutors and agency lawyers, they are the connective tissue. When conflicts intensify, they often face the hardest choice: comply with leadership direction, protect professional ethics, or leave. In our verified record, the quitting pressure is most clearly documented in prosecutor offices and DOJ-adjacent settings, including reporting about resignations, threats in Minnesota. Congressional oversight. House Judiciary Democrats have issued public demands for DOJ answers related to Minnesota incidents. Whether you agree with them or not, this is a signal that the conflict is also becoming an oversight and hearings issue. Now let's translate all of this into real-world impact. Real-world impact. What this changes for people, politics, and credibility, rule of law confidence. When a federal judge writes that an agency has likely violated more orders in a month than some agencies have violated in their entire existence, and then adds, ICE is not a law unto itself, that's a public trust alarm bell. If you're a regular viewer, here's the nonpartisan version. Courts rely on compliance. The executive relies on courts for legitimacy. When the relationship breaks, everyone pays in instability, litigation flood, and institutional stress. Reporting describes a surge of cases, internal strain, and prosecutor churn. Even without endorsing every characterization, the verified point is that resignations and threats to resign are being reported in connection with how investigations and enforcement are being handled. Narrative inflation, how agency court fights morph into White House lawyers quit. This is where your title comes in. Online ecosystems compress complex, document-heavy conflicts into a single image. The lawyers are gone, the shield is down. That can be emotionally satisfying and sometimes completely wrong. Based on this source pack and time window, we can verify court orders, warnings, and prosecutor office strain. We cannot verify a mass resignation of the White House counsel's office. So if you publish that as fact, you're stepping off the verified ground. Now, what happens next? What happens next? 3 scenarios clearly labeled Scenario A, most likely. More court orders, plus compliance showdowns continue. If judges keep receiving emergency filings alleging unlawful detention or delayed compliance, courts may issue more show cause orders and may again threaten personal appearances by senior officials. What would confirm new court orders naming officials, docket entries setting show cause hearings, and documented compliance timelines. Scenario B plausible: internal DOJ agency reshuffling and more resignations. If internal legal pressure rises, especially around controversial investigations, additional prosecutors or officials may resign, or leadership may reassign responsibilities. What would confirm? AP Reuters.WAPO confirmations of departures, official statements, resignation letters, or congressional testimony. Scenario C, high impact, less likely. Contempt findings or sanctions in major disputes. Courts can impose sanctions, and contempt is a real escalation path. But it's serious, fact-specific, and usually carefully staged. What would confirm? Explicit contempt rulings, sanctions orders, or findings after hearings. Now, the most important section, what we still don't know and what to watch. What we still don't know yet based on this window. Whether the viral claim about White House lawyers quitting mid-crisis refers to a specific named resignation that simply hasn't been verified by Tier A outlets, or whether it's a mislabeling of DOJ prosecutor turmoil as White House lawyers. Whether additional court-identified noncompliance will be contested with new filings, factual clarifications, or stays on appeal. What to watch next? He checklist. New court orders in Minnesota cases, especially anything setting personal appearance hearings again. Appeals. Stays in the Virginia appointment dispute, whether DOJ seeks stays that it hadn't sought as of the John 20 order. Confirmed resignations, names, roles, and whether they're White House counsel, DOJ leadership, or U.S. attorney offices. Congressional oversight actions, hearings, subpoenas, or formal letters expanding the record. If you want to verify this yourself, don't trust the headline, trust the documents. We're linking the orders and top reporting in the description. Neutral disclaimer: we report what is documented and we label what is not. If new primary documents confirm White House counsel resignations tied to this dispute, we will update, because accuracy outranks virality.